Hey, on today's Q&A, I'm going to go over a common question that I'm asked is whether or not the federal government can indict me if the state is prosecuting me, or can the federal government indict me if the state chose not to prosecute me? And the answer is yes. And some people do not find this to be logical at all, but it's like what you have to understand is that we really have two different forms of governments. We had individual states who collectively formed a country, and that's our Federalist approach. And so what we have is we can have two dual sovereigns, okay? Louisiana is a separate sovereign than the United States government. So Louisiana can prosecute you, the federal government can prosecute you. And interestingly, you can be acquitted in one and convicted in the other on the same evidence in front of a different jury. People don't seem to understand that. The only analogy I can give is if you remember the O.J. Simpson trial, he was found not guilty in the criminal trial, but liable in the civil trial. And that's not really quite dual sovereign, but it's just an example of there are mechanisms in the law that you can be adjudicated for the same conduct and get different results. Now, there's something you have to understand. It's called a pettit policy. This is a Department of Justice rule. It's based on a case, and in essence, what it says is that the Department of Justice will refrain from prosecuting someone in state court if the outcome of that state court proceeding is substantially similar than what they would have received in federal court. And that's the general provision. Now, a local U.S. attorney's office could go up to Main Justice and the actual Attorney General and make the case as to why they should still prosecute somebody who's been adjudicated in state court for the same type of crime. And that does happen. But sometimes you want to play the two jurisdictions if they're going to kind of work with each other and only prosecute you in one place to try to structure a sentence where, while it may look the same with the number, depending on where you serve it, you may actually be released earlier with a conviction in one jurisdiction over the other. We also want to know that in cases of dual prosecutions, the sentencing guideline has a new provision called United States Sentencing Guideline 5G.3, which allows a judge to sentence someone concurrently to anticipated state court time in the same proceeding. And that's kind of new. When you do the reverse and you want to have the state court judge run your time the same with a federal court judge, you also want to say concurrent and coterminous. I do not know why you have to say the word coterminous, but the Bureau of Prisons seems to like that magic word. So that's federal and state joint prosecutions. If you have any questions, you can email